So in this video, we're going to talk about some of the antitrust laws, collusion, and the impact this has had on sports leagues and the franchises. Because in reality, you do have individual teams. So for example, with the NFL, you have 32 different teams, but the league acts as one in doing things like negotiating, setting the rules, and so forth. So the first thing to really note here is the Sherman Antitrust Act, and a couple quotes from that. Every contract, combination in the form of trust or otherwise, or conspiracy in the restraint of trade or commerce among several states or with foreign nations is declared to be illegal. And a second one is, every person who shall monopolize or attempt to monopolize or combine or conspire with any other person or persons to monopolize any part of the trade or commerce among several states or with foreign nations shall be deemed guilty of a felony. So think about that. You have a bunch of teams all working together, and they have that market. So all the quote-unquote firms in that market are working together. So because of that, in reality, just on the surface, all sports leagues do appear to violate the Sherman Antitrust Act under collusion. So let's talk about a pretty important exception / anomaly, and that is the baseball antitrust exception. So baseball and Major League Baseball enjoys an absolute exemption from all federal antitrust laws with no time limits, no government oversight, and no regulation of its pricing policies. Now, this continues to exist even though courts and legislative branch recognize that the baseball exemption defies all legal and economic logic, and any changes have only been cosmetic. So this goes back to a former league, the former baseball league, the Federal League, which tried to form a third league in 1914 and 1915. So you had the National League, you had the American League, and then you had a third league which was trying to form, which is the Federal League. Right? Now, the outlook for this did look promising, but the Federal League filed an antitrust lawsuit against the 16 owners and 3 members of the National Commission that oversaw the 2 major leagues. So there was a commission that oversaw the National and American League plus the owners. Right. Now, based on the 2 sections of the Sherman Act, which I just mentioned, they brought it on the idea that these teams and the overseeing body was being a combination, conspiracy, and monopoly. Now, the Federal League filed its suit in the U.S. District Court of Northern Illinois before Judge Kennesaw Mountain Landis. Okay. Now, Landis was a baseball fan. All right, so he's a fan of National American League, and he scolded the Federal League's lawyers, saying that a tax on baseball would, and I quote, would be regarded by this court as a blow to a national institution. He refused to issue a ruling for over a year, by which time Major League, National American League, had reached an agreement with all but one of the Federal League owners, driving the Federal League out of business. Now, there was a single owner, Ned Hanlon of the Baltimore Terrapins. He held out. And so Hanlon filed his own suit, which was the Federal Baseball Club of Baltimore, Inc., the National League of Professional Baseball Clubs. Right? And he was awarded a settlement in federal district court. This case, however, was overturned on appeal, and so he went all the way to the Supreme Court. And so in 1922, again, this is a league that tried to form in 1914 and 15, so this is years later. In 1922, the Supreme Court ruled unanimously that baseball was not subject to antitrust laws. Okay, again, unanimously. Now, in an opinion, one of the Supreme Court justices said baseball was a public, and I quote, a public exhibition, not commerce. Okay? And that interstate travel, which would have made baseball public to these, or baseball subject to the federal legislation, was purely incidental. And staging these exhibitions, okay, so the games. So the rationale for the decision has never really been clear. The Supreme Court consistently denies other industries, particularly other sports, the right to use the federal baseball ruling as a precedent. Somehow the court maintained that other sports were interstate commerce while baseball was not. Again, it's a really kind of weird thing. So then in the early 1950s, George Toulson, who was a player with the New York Yankees farm system, resisted it being sent back to the minors. He resisted it being sent back to the minors, and so he sued the Yankees, claiming that the reserve clause violated antitrust laws. So the reserve clause, which was part of all baseball contracts until 1975, which is when free agency started, allowed the teams to maintain the rights to the player for their entire year, for their entire career. So now teams can become free agents. They can be, sign with teams that they want after a certain period of time. But prior to that, a team had control of that player forever. And so this prevented players from soliciting competing wage offers. They didn't have to, teams did not have to compete with with other teams for the players. And so, again, his name is George Toulson. Now, his suit worked its way through the courts, and it kind of got all the way up on baseball's antitrust exemption. And it became clear that this case was going to be going to the Supreme Court. And so one of the courts kind of postponed further action, assuming that it would be settled. Now, the Supreme Court took this in action, saying that Congress had signaled its approval of baseball's antitrust exemption by refusing to take any action against it. All right. So the Seller Committee was Congress, and that's where it had kind of gone to. All right. Let's jump ahead. And so in '68, you had Cur Flood, who was a star outfielder for the St. Louis Cardinals. And after a good season, he asked for a $30,000 raise. The Cardinals then traded him to the Phillies, and he didn't like that. And he asked the commissioner at the time to repeal the trade, which was denied. So then in 1970, with the support of Major League Baseball Players Association, Flood filed a lawsuit in the district court against the Commissioner of Baseball, asking for $3 million and for free agency. The judge ruled in Kuhn's favor, who was the commissioner at the time, arguing that there was higher ground than mere commerce. And an appeals court also ruled in favor of the commissioner. This went all the way to the Supreme Court. Now, the Supreme Court denied this lawsuit again, saying that there were basically some things like that, but basically the Supreme Court agreed that the teams did have the right on it. And so with that, however, they eventually, sorry, I know it's a little bit confusing. The Supreme Court eventually agreed with Flood and said that, they can't do this, Major League Baseball. And because of that, that is where free agency started. And so the teams can no longer control the player for their career. Now, in 1998, Congress placed limits on this antitrust exemption by passing what's called the Cur Flood Act. And this limits baseball powers only in the area of labor relations. Okay? So Major League Baseball can still limit the number of teams and restrict their ability to relocate, but this has no impact on the labor markets. And the players' rights to sue is highly limited. So just kind of an overall summary of this. I know it was a lot there, but Cur Flood, by suing, was able to get the Supreme Court to say, well, yeah, this doesn't really apply. Even though we've said that baseball is free of antitrust, they really can't control players like that. And so that's how free agency started. But then Congress basically said that Major League Baseball still has all these same rights to act as a monopoly, just not under, controlling the players. So overall, Major League Baseball has had unprecedented control and ability to have monopoly power that no other leagues have. Now, having said that, looking at some of the other leagues, all other major professional leagues have had serious challenges to their monopoly power. Sometimes the teams had to absorb rival leagues in order to avoid the lawsuits that they probably would have lost from those. So of the 123 franchises in the 4 major North American leagues, 40 of them began as members of rival leagues. So 40 out of the 123 were in a rival league that was absorbed as a result of lawsuits. And others were created in response to prevent these further teams from coming in. So, for example, in 1976, the NBA ended a 10-year war with the American Basketball Association by allowing the teams in there. So you had the Denver Nuggets, Indiana Pacers, New York Nets, and San Antonio Spurs, who were part of the ABA, to join the NBA. 3 years later, the NHL had a costly legal battle with the World Hockey Association, and ended up absorbing those teams. Okay. So again, it's unlike baseball. These other teams, NFL, NHL, NBA, don't have those same protections, while baseball does. There are some limited exceptions to this on the NFL side. One is the NFL and television. So in 1959, Pete Rozelle, who was became commissioner of the NFL, the NFL still lagged behind baseball and college football. Right? Now, to get the league-wide rights for broadcasting, Rozelle had to overcome a lot of boundaries because these broadcasting rights, as they're acting in a monopoly, were illegal. And in 1953, they were expressively prohibited by having a league-wide contract. Basically, the idea was that each team had to negotiate their own broadcasting contracts. Now, Rozelle lobbied Congress to grant a limited exception from the antitrust laws for both football, basketball, and hockey that would only apply to negotiating for broadcast rights. Right. So in 1961, Congress passed the Sports Broadcasting Act, and this granted the exception. 8 years later, by 1969, 8 years later, revenue from broadcasting rights had risen by a factor of 5-fold for the big market teams and 13-fold for the small market teams. Now, so clearly this was effective and a good thing for the league to be able to get more money for them. Now, there is one caveat to that. the NFL had to make a concession when it came to getting Congress to let them do that. And that is that they said they would not compete with college or high school football. Okay? So they would not have games at the same time as high school and college football. This is why you do not see any Saturday games or Friday games. That's when high school and college football play. Now, you do see that sometimes in late December because college ends at that point. But if you've ever wondered why the NFL does not have games on at the same time as college and high school, that's why. It all goes back to the Sports Broadcasting Act. So, yes, I know this is a lot here, but it just kind of gives a broad overview of antitrust laws and when leagues have and have not been able to kind of get around those.